Welcome to this one and only broadcast of the Arch Crew Compensation Group. My name is Jon Maguire. I'm chairman of that compensation group. I'm also the co-founder of Crew Investment Management. A little bit of background before I pass over to my guests here this afternoon. The fund's raised 400 million with a performance track record which was either defying gravity or, as we believed, was based on private market valuations being very different from that of listed market securities. In the end, in the unravelling of what happened next, that is not true. And the information that we were provided, the information received by investors and advisors alike, has been woefully poor, up to the point of suspension of the £400 million range of investment funds, which took place on March the 13th, 2009. I want to now basically discuss what's happened since then, what we now know, what we've done about it, what we can do about it going forward, the options for firms of financial advisors, the options for clients. And so I have with me today the lawyers who are representing the interests of the compensation group, which is Anstey based in Exeter, partner David Turner and associate Alan Hughes. Welcome, gentlemen.
Thank you, John.
I think it might be just useful just asking you to explain who Anstey are, David, and what you do.
Fine, and thank you. Anstey are a top 100 firm of solicitors. We're based in the southwest. I'm David Turner. I'm a partner in Anstey, and my specialism is civil litigation, or dispute resolution as it's sometimes called. And inside that, I specialise in financial services disputes. I'm assisted in this by my colleague Alan Hughes, who is not a civil litigator, but who himself specialises in the financial services industry. And Alan, you might want to say a few words.
Yes, I specialise in financial services. That's all I do. So I represent a range of different companies within that sector. And I originally, in a former life at a former firm, represented Crew and dealt with their authorisation with the FSA, which is how I came to know John, and that is the brief connection between us.
So people want to know who got Crew authorised. You're to blame. Okay.
I was the facilitator. Yes.
Right. I think I'd like to break this down into various chunks, looking at the work that we've undertaken as the action group with Anstey to move us to where we got to with council. So the first piece of work was really to start to look at the various rules and regulations under which all the parties involved with the CF Arch Crew funds sit. So could you just name for me, Alan, who the main respondents actually are in terms of depositories, their role, the ACCG, their role, Arch, their role, and the relationships that sit behind those firms from a regulatory viewpoint?
Right, okay. The main parties are, we have the authorised corporate director of, there's two main sets of umbrella funds. The authorised corporate director of both is Capita. Right. And the depositories of one set of those umbrella funds is HSBC, and the depositories of the other set is Bank of New York Mellon.
Now, just so, because the private investors are listening to this,
yes.
So when we say the authorised corporate director, what actually do Capita do? What's their responsibility to investors?
Well, the regulatory responsibilities on both Capita as the ACD, authorised corporate director, and Bank of New York and HSBC as depositories, and as the authorised corporate director, Capita are broadly responsible, without going into too much detail, for making sure that the funds are run in a certain way in compliance with the rules, in compliance with their own prospectuses, that the investments are made in accordance with the objectives of the fund as stated in the prospectus, etc. Right. So they have to keep the funds on track.
If you like, they really are there to protect the interests of investors.
Yes, by ensuring that the fund is run in the correct way.
Right, okay. And what do the depositories do?
The depositories also have a sort of overseeing role, and one of their roles is actually to make sure that Capita are doing their job properly. So
they hold the assets of the fund?
Yes, broadly speaking, yes. They're sort of higher level, not involved in as much detail as Capita, but one of their key roles is to make sure that Capita are doing their job properly. So there's almost 2 layers of protection for
Right.
the
And
investors.
without going too much into this, the issue of valuation of these funds, which is where so much of the problems have come from,
Yeah.
that people were buying into investment funds that were never worth what they were being told.
Yep.
The pricing responsibility sits with both Capita and the depositories.
Yes, I would say so.
Right.
There's a relationship between them where they both take some responsibility for that issue.
Yeah, and there are major regulatory rules surrounding pricing.
Yes, that's
Yes,
right.
and what the underlying assets of the funds can be.
Yes.
Yes, right, okay.
And
But just so that everybody's aware, we're not here to spill the beans big time, because we need information which we hold confidential, even from members of the ACCG, because we need that to be within our remit and our understanding and knowledge, but not in the understanding and knowledge of potential respondents in law, such as Capita, such as HSBC. So I don't want to go into specific investments. Yes, I just want to keep this fairly high level, but we all understand the regulatory issues that are beginning to run. Okay, so then we have the final piece of the jigsaw puzzle is Arch.
Yes.
What was Arch's role, and where do they fit in regulatory terms, in liability terms, on a regulatory basis?
Well, Arch were the investment managers, if you like, of the funds, but they were actually retained by Capita as the ACD. So Capita, in this particular type of fund, Capita are responsible for the investment management of the fund, and in this case they chose to outsource that, if you like, or subcontract it out to Arch. So from a regulatory perspective, under the rules for these type of funds, Capita as the ACD are actually responsible for everything that Arch does. And so from a regulatory perspective, Arch perhaps don't have direct duties. They're actually on Capita.
Right.
Because the rules say that even if they choose to outsource it, they are still responsible for everything that Arch does.
Right. In terms of the sort of civil proceedings, litigation, yes, that's quite good for us, because whilst Arch aren't a very big firm, Capita are a FTSE 100 company, HSBC a global bank, and Boney Mellon aren't small.
Yes.
And so we've got 3 respondents with very, very substantial financial resources, if you could get judgment against them.
Well, all 3 have deeper pockets than Arch would have, and have clear regulatory duties. So if we can establish that those duties have been breached and they've caused losses to the investors, there is the potential there for significant recovery.
But David, from a litigation viewpoint, they do have resources.
The first thing you should do, however good your case is, and even if you are successful, if the person you're pursuing has no money, then it really is close to pointless. But here, as you say, John, at least 3 of the 4 potential defendants have significant funds. Right. So, as Alan says, if we are successful or we can negotiate some sort of recovery, there won't be an issue about we can't afford to pay.
Right. Okay. But they also have big checkbooks to defend them.
Well, that's the other side. They do have big checkbooks to defend them. They can afford expensive lawyers, and with the sums involved, I anticipate that that's a route they'll take.
Right, okay. So that we'll get onto that when we talk about how we move forward, but it's an important point. Okay. So when the compensation group was formed, yes, we started to look at the regulatory backdrop to what had gone on. I was able to bring certain information to the table, which I was aware of. I also then received information from the former Chief Investment Officer of Arch, Michael Dirks, about his concerns relating to the management of the money, not just the actual underlying investments that the funds were making, the mechanism by which they were making them, i.e. shrouding them in secrecy in Guernsey cell companies, and somehow listing those vehicles so that they would comply with rules when the underlying investments never would comply with rules. Massive conflicts of interest that he identified in the firm, and more and more of this is coming out, whereas Capita sort of set up a compensation a bit within their report on accounts because they feel that, oh my God, we're then possibly culpable. Now we have the new directors to those Guernsey cell companies coming out and saying, well, the valuations these things are shot. The underlying investments just don't stack up. Now, I don't want to dwell on those things because that's a matter for the next step in legal terms, which we will get onto. But in terms of our analysis of possible regulatory breaches, Alan, under various headings, when we submitted to council, what was the main thrust of what we felt we were saying?
We were saying to council, look, these are the parties involved, and we didn't focus too much on Arch, we focused on the Capita as the ACD and the two sets of depositories. We then said to council, look, these are some of the main regulatory duties, but council will be aware of those anyway. And the key thing was, we said, Jon Maguire in particular has some knowledge of what went on within these funds. These are some of the things we think went on, although we don't have all the evidence yet to prove it. This is the whole purpose of this exercise. What do you think, council, about the chances of success making a claim for breaches of those regulatory duties based on this information, assuming it's roughly correct? And council came back very positive and said it looks like we could have a pretty strong case against some or all of those parties based on the information we have, but obviously we need to go a lot further if we're ever going to get there.
Right, so let's take this, so we bring people time-wise up to speed with where we got. So we did a lot of early doors looking at potential regulatory breaches.
Well, what their duties were,
and ways in which we think they failed.
Yes.
And that
which is where you came in, John.
And that became quite a significant document.
Yes.
At least by length, because there was quite a lot that didn't really sit very comfortably in terms of compliance to the regulatory rules. Now, I also want to get this right. The potential breaches that we have found give the right for investors to sue.
That's right. Yes. Under the Financial Services Markets Act, breaches of certain FSA rules give a private investor a right of action against the person that's breached them. And it's pretty clear in this case that most of the rules we're talking about do give that right of action to a private investor.
Right, so there is a legislative framework already in existence into which we are moving. So
that's right.
We're not looking for changes in regulation or...
No, and we're not trying to create new and radical law in the courts. Right. Yep. The framework is there. We think it sits squarely within that framework, subject, of course, to getting all the evidence, etc.
Okay, so David, now we move from a position where we sort of have half an idea of the regulatory breaches that these firms are going to be stuck with. Yeah, we then have to prove it. Okay, and that moves us to what is called pre-action disclosure. Could you just explain what that is, and then also the basis on which we went to council?
Yeah, we think we've got a good case, John.
Right.
Council agrees with us. There's one thing, having a good case, you have to prove it. For that, we need documentation. At its simplest, are the potential defendants, their internal mechanisms, their internal workings, how they managed the funds.
Right.
Those documents are certainly what in law is called disclosable. They will be obliged, if someone brings a complaint, to give those papers over.
So if we wanted to know what were the actual underlying investments of these investment funds, because at the moment we don't know that.
Yes.
Okay, and everybody's hiding. No one's going to tell us. Yes. What pre-action disclosure gets is it forces that information out.
Correct. It's information that we could probably get if we decided to bring civil proceedings, but that is a step. That's quite a difficult step to take, and it exposes a lot of people to costs. What we ideally want to know is we want the documents so as to make a decision to take the next step. Right. It's cleaner, it's safer. That's what pre-action disclosure. The pre-action means before proceedings.
Now, explain then what's gone on at the minute. The ACCG, well, you on behalf of the ACCG, wrote to...
We wrote to all four potential defendants, setting out our position, saying we thought we had a good case, giving some details, saying that to a certain extent we can't give all the details because we don't know them, and asking voluntarily for those parties to give pre-action disclosure.
Right.
We anticipated the response to you, which would be thank you but no thanks, and we did get that politely. It's difficult. A party can't just say no, so they've got to wrap it around in, we need more information before we can give.
So this is this whole thing about fishing trips. The courts don't like seeing a disclosure of information which says we want to know everything, every bit of paper, every email ever produced within your firm for the last 5 years, because they'll say that's completely unrealistic.
It could be a weapon that can be used where the courts don't want to use it. So we have to hone in and provide further information. Yep. On that basis, we went to council again. We had a fair idea ourselves what we wanted, and council said what you need to do is to frame this information and have these parties and write this sort of request. Then it'll be very difficult for them to say no.
Okay, so